Impact of Influence, the Murdaugh family murders. This is the unfolding story of a powerful South Carolina family, the mysterious deaths they are linked to, and our quest to bring you the truth. Hello, friend. I am Matt Harris. Seton Tucker here as well. We are grateful you're going to spend some time with us. Always appreciate that. Impact of Influence on Facebook. And starting rolling with our Impact of Influence YouTube channel. We'll have that on the Facebook page so you can find it. Part of the Evergreen Podcast Company. And we have had some things happen because we've been waiting for this big moment. How close are we going to get to an Alec Murdaugh retrial for the double murder he was convicted of his wife and son a couple of years ago? And this was the first stage, this hearing that took place in Columbia, South Carolina, under the guidance of Justice Toal. Seton, you were there, and it was, I think I should say, went a lot differently than I think that a lot of people anticipated.
It did. It was actually not a hearing. It was a public status conference.
Okay, yes, thank you.
She was, it's kind of started off a little bit later than expected. Alec Murdaugh was there. And prior to it starting, he was chatting with some of the legal team, and he seemed to be in good demeanors. He was smiling and laughing, but that quickly changed as the conference progressed. It definitely was not a good day for Alec Murdaugh.
I think, and I was watching it, and it's probably a horrible analogy because it's much more serious than football. But I feel like it was right before kickoff when Jerry Jones and all the Cowboy fans this past weekend were like, we're gonna win this one, and then we're gonna go to the Super Bowl, and then before you know it, it's like 28-0, and they're all sad. And that was like Alec Murdaugh watching the Green Bay Packers stroll over him because Justice Toal wasn't having much to do with what his defense team was presenting.
Well, and I posted a picture to our Facebook page, which I thought was so interesting. One of the pool photographers from Post and Courier took this picture. And it is Alec Murdaugh just with his head and his hands, and Jim just looks frustrated. Philip Barber looks kind of red-faced, and you could tell that team was definitely not having a good day. The picture captured it perfectly. So go to our Facebook page and check it out.
Let's explain why it was not great and some of the other things. Will Lewis was there, who is the lawyer for Becky Hill.
Yeah, and Dustin Bamberger, who is her other attorney, he was not there. Also, Joe McCullough, who represents one of the deliberating jurors and also the dismissed egg juror, and Eric Bland, who represents 4 of the deliberating jurors, were all in attendance. Interestingly, none of Alec Murdaugh's family or friends appear to be in attendance.
And it started a little later than expected. As the attorneys were in chambers with Justice Toal. They mentioned that later in the, I keep wanting to call it a hearing, but later in the conference. Later in the conference, about how they'd hashed some things out ahead of time. And so it started, 30 minutes later or so?
Yes, and really another weird thing happened before it started. This man approached the media and said, they're talking about me in chambers, that's why it's starting late. And he handed us a legal filing that I guess he had filed, and it was dated January 15th, 2024, and it read, "Motion to disqualify Judge Jean Toal for participation in conspiracy against civil rights of citizens." It was addressed to 23 members of the Senate Judiciary Committee, Chief Justice Beatty, Justice Toal, Attorney General Alan Wilson, Dick Harpootlian, Jay Bender, and Michael DeWitt with the Greenville News. It was really very strange. I tried to read it and I didn't understand it, but just like everything else, Murdaugh, it was odd.
And it doesn't seem to have any real legs as far as
they did not address it in this conference at all.
Yeah. So then the defense tries to pitch their case to Justice Toal. And what was the State versus Cameron case law that they tried to refer to?
Well, this was a 1993 federal court case in which the bailiff had conversed with a forelady during the deliberations. Apparently, the bailiff told the forelady that they should not worry if they were deadlocked because the judge was fair. And this was considered misleading because it tended to lessen the jury's sense of responsibility by implying that if they rendered a verdict of guilty without mercy, that the judge would have some discretion in sentencing. So they made their case that this was material and this is what they should rely on.
And they referred to some of the Clerk Hill's communication that has been talked about in affidavits, which was things like don't be fooled by him, watch his demeanor, when they were talking about Alec taking the stand.
Right. But Judge Toal quickly indicated that there was plenty of state law that would apply, and she referenced State versus Green, which is what the state argued was the proper case law to follow.
And State versus Green was a bailiff with improper communication.
Also a bailiff.
Yes. Yes. So, yeah, the other two that you mentioned, before that was the bailiff. This one's the clerk of court. And let's see, it was improper communication with jurors. Green had been convicted of murder and desecration of human remains. Jeez. In this case, the trial court questioned each juror and the bailiff and proved that there was, quote, no reasonable possibility that the comments influenced the verdict. It was determined that a Remmer hearing was not necessary. And that Remmer hearing is, was about bribery. So let's go to Remmer. Talk about that for a minute.
Yeah. So in Remmer, a juror was approached by an unnamed person and was told that the juror could profit by bringing a favorable verdict to the defendant. So Green says that this attempted bribery situation in Remmer is different than this case because it doesn't go to the merit, and it's a far cry different than trying to bribe a juror.
Right. But what I did see that I thought was interesting, and I'm no attorney, but one of the quotes from the Green case is there was no reasonable possibility that the comments influenced the verdict. It was determined that a Remmer hearing was not necessary. No, so the question I had, and I reached out to an attorney about it, was there's no reasonable possibility. It doesn't say that if the jurors say no, right? So it doesn't say if all the jurors say no, then it's clear. They said reasonable. So is it possible then the jurors could say no, but the justice could say, but I think there's reasonable possibility that it did have an influence, even though you said you didn't, right?
Right.
I mean, now I've been told maybe I'm full of hooey on that because it still is the question of whether it rises to a Remmer level
Yes.
or not. So
well,
that remains to be seen.
Nonetheless, by adopting Green as the standard, Justice Toal is keeping the burden with the defense.
Yeah, because that's important to point out. You just said if she had flipped it and gone with the Remmer, I guess it would be, the burden would have been on the state to prove it didn't have an effect.
Right.
I suppose now the defense has to prove it did have an effect.
Right. So that was that whole thing that we've discussed before that that the defense was saying if it was Remmer or what was the other case?
Green?
No, Green is the one they're relying on.
Oh,
Cameron.
Yeah.
So if it was Cameron or Remmer, then just having these improper communications are enough for him to get a new trial.
In the Cameron case, yeah.
In the Cameron case. But according to the Green case, it would have had to affect the outcome of the case. So it would have had to make a difference on the verdict.
It was very clear that she's going with that.
It was
It
was very clear. And I really think that a big factor in that is this is state law versus federal law.
That could be.
I think that influenced
I had an attorney tell me they thought it was, the question was even, state was involved, but she thought that it was how that Justice Toal isn't seeing it thus far. And again, she said she can change things. Thus far, as rising to the Remmer level.
Right. She said her contention is prejudice must be proven, not presumed.
Okay.
And I want to discuss that because in the day and age that we live in, you can't, especially with the Murdaugh case, somebody is at the store and someone's discussing the case just briefly and they hear something. You can't really possibly eliminate all external influences.
And they're not sequestered, right?
They weren't sequestered, so you would have to be living in a tent down by the river, not to
by the river,
not to have heard anything about it. And not saying that they did, and they were told not to listen to media, and they were told not to hear things. But somebody yells out the window, Murdaugh's guilty, on their way out of the courthouse. You can't control that.
I think the defense would argue the difference is it's a clerk of court. It's a court official.
Court official, yes.
Not just a random dude at the Piggly Wiggly. So that's what they would argue. So we then usually should prejudice must be proven, not presumed. The defense was certainly hoping that it would be the opposite. Justice Toal, what did she say about the witnesses? This was a blow to the Murdaugh team.
She says that she only intends to interview the 12 jurors who deliberated in the clerk of court. So she's removing the egg juror, the alternate who submitted affidavits, and she really wanted to keep this hearing, she used the term focused and very targeted. And she also said that this was not the trial of Becky Hill. So she really wants to keep this very limited, and indicated that the questions she's really interested in asking are things like, were there improper communications, first and foremost? We need to know if these happened. And if they did those communications affect the verdict?
Yes, and that, to me, is going to be her simply saying, did it affect, here's question 1, anything said. Question 2 to the juror, did it affect you?
Right. And
it could be that simple and quick.
She says she's not going to address a lot of these allegations against Clerk Hill that occurred after the trial. For example, her book and the plagiarism.
Misappropriation of funds.
Right. Like that doesn't have anything to do with the trial. She's not going to address this Facebook stuff with the egg juror.
Murdaugh's attorney, Harpootlian, kept trying to push the point of, well, we want to go toward her credibility. Don't we have the right to go to her credibility, right?
Right. And they said something about this 2,000 plus emails. She doesn't intend to go through the 2,000. Yes. And then I think Harpootlian said something to the effect of, well, we don't expect you to go through 2,000 emails. And she said, well, you put that there were 2,000 emails in your brief. So she was not really having any of that.
No.
They also discussed these summaries that SLED did.
Okay, back up for a second, not to interrupt you. Just to point, I think we should mention too is she said Judge Newman, any attorneys, none of those people are going to testify. They were on the list. But so any attorneys involved and Judge Newman, not. They're out.
I think it would have been a really long shot to have Judge Newman when they put that in when the defense put that in the filing that they would like to have Judge Newman as a witness. I thought, woo, I didn't think that would happen.
Or Creighton Waters, or
Creighton Waters, or Creighton Waters, exactly.
Okay, so sorry to interrupt because so we are on to the Facebook stuff, I believe.
Yeah,
the SLED summaries.
Oh, yeah, the SLED. So SLED conducted interviews of us, I think, all but maybe 2 of the jurors. I know for sure they didn't
do Joe's.
They didn't do Joe's juror number 630, and we'll get to 630 in a minute. But I believe there was possibly one other juror who has not been interviewed by SLED, but I wasn't clear by what I heard at the hearing if that was the case or not. But nonetheless, there are these summaries of the interviews that SLED conducted, but there's also accompanying videos. And the defense claims that the videos need to be watched because the summaries don't really include everything that's necessary for the judge to hear.
Well, I think that's fair, right?
I think it's fair, but and Justice Toal kind of backed off of it a little bit. So she said that she kind of wanted to conduct this interview of the jurors, these interviews of the jurors, and that she wanted to do her own fact finding. But the defense is saying, no, we need you to watch this because some of these things may impeach what they say.
Because they changed their story.
She's getting some zip drives, apparently, of these interviews and the summaries, and I'm not sure if she's going to listen to those or not.
No, because she mentioned something about we're not going to pick apart if they said one thing one day and one thing the other day. Something along those lines. I'm paraphrasing, but yeah. By the way, Justice Toal thinks the jurors, it's a hard word, jurors.
I know, it
right?
is.
Jurors will, that one day, one day to talk to interview them. But explain what she said about how the interview will be done with the jurors.
She says that it will be conducted in open court, and there will be a camera of the court TV feed, but their faces will not be shown.
Mm-hmm.
When the attorneys representing the jurors, Eric Bland
Mm-hmm.
and Joe McCullough, Eric Bland indicated that he would prefer them not to be filmed, it not really be in open court, but
Joe was McCullough was on board
on
with
this
that too.
on the same board. But Justice Toal said that there's a precedent of this happening, and you also have to think that these jurors were seen by members of the public who attended this trial. It's
Mhm.
not. I mean, I think we do need to protect their privacy, but I think
A lot of it's out there.
some of it's out there. Some of them appeared on different media outlets, interviews, and that sort of thing. So
Joe McCullough's point, I think, and he will correct me if I'm wrong, was that by putting them in front of a full gallery,
right.
it puts like this. People react differently when there's a full gallery and a lot of pressure. There's more pressure.
Yeah, we talked
whether it's identifying him or not. It's not about the identifying with him as much as you act differently, right?
Yes, and we talked about that, how intimidating it must have been for the egg juror when she was questioned in front of a packed courthouse.
Mhm.
So certain people, I personally get nervous when I have to get up in front of a large group of people and talk. So I could see that would be very intimidating.
And to be the one, let's just play crazy game here. To be the one that says I changed my verdict based on what Becky Hill said might be different to say in front of 100 people than in front of a couple lawyers and a justice.
Exactly.
I mean, I'm not saying that would happen, but that's his point. That
But Justice Toal does seem committed to
Yes.
transparency and making sure that the public is seeing this process unfold.
Mm-hmm. Mm-hmm. Yeah. So see, she'll be. Clerk Hill will also be Becky Hill questioned in front of the open court with cameras.
Right, and she will be questioned, I believe, by attorneys, not just. That was my understanding, not just by Justice Toal.
Right. Justice Toal's going to do the jurors. No attorneys are allowed to question the jurors. Yeah, it's as of now.
Now, and there's a good possibility that Clerk Hill will plead the fifth.
Which we had thought a few weeks ago or whenever it was that would be impossible. We were kind of led to believe that because she's already commented on something.
I don't know that we said that was impossible. We said that they may argue that she would be forced to answer some of these questions because of the affidavit that she
and
filed.
She still might.
Because that would be waiving her right to... And we don't know exactly what will happen with that. But if she does plead the fifth, the judge will have to take into consideration her credibility and what that means to her credibility.
Especially depending on what question she took the fifth to, right? There could be some that she'd be like, okay, I mean, there's some that it might be more important to Justice Toal than others.
Right.
Right.
Yeah. Yes. Does she plead the fifth to everything, or does she answer some of the questions? Doesn't answer some of the other questions? We don't really know exactly what will happen, and I don't think we'll find out until the day of the hearing. It was interesting because Dick Harpootlian asked her attorney, Will Lewis, if he would make her available for a interview. And he said he would take that under consideration.
Yeah.
I think that's a no.
Yeah, he was up there for like a half a second. He wasn't up there very long.
No, he was not up there long. And I will say that Justice Toal did say that she was not ruling in a vacuum, and this is what she's seeing the process look like so far. But things could change based on evidence that presented to her.
She did leave it open.
She did leave it open a little bit.
Just a little, but it's still a bad
She
day.
seemed pretty strong that it's just going to be the sitting jurors, or the deliberating jurors who are going to be interviewed, because that's, in her opinion, what really matters.
It's going to be Becky Hill and 12 jurors.
Right.
That's what it appears to be, 13 people. And going to be saying, something inappropriate said? Did it sway you? Bam, next.
Okay, so let's talk about juror number 630, who is Joe McCullough's client, and she seemed to make the most damning statements against Clerk Hill. So let's look over some of her affidavit, which was signed in August of 2023. She says that towards the end of the trial, after the President's Day break, but before Murdaugh testified, that Clerk Rebecca Hill told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which she understood to mean that Mr. Murdaugh would lie when he testified.
That's a pretty big accusation and a pretty, to me, inflammatory comment if true.
Right. And then she says that she was instructed to watch him closely immediately before he testified, including looking at his actions and looking at his movements, which she understood to mean he was guilty.
Hardcore stuff.
Right. She talks a little bit about some, I guess, the former foreperson being criticized for handing Alec Murdaugh box of tissues.
She talked about some jury stuff, but we, it doesn't matter what the jury is saying, right?
Right. What she doesn't really say to me clearly in this affidavit was that these communications
made her change her verdict.
Made her change her verdict. She does say when deliberations began, Miss Hill told us that this shouldn't take long and that if we delivered past 11 p.m., we'd be taken directly to a hotel. We've been driven from our homes that morning and we're not prepared to stay overnight. Additionally, smokers on the juries asked to be allowed to take smoke breaks, but were told that they could not smoke until deliberations were complete. She goes on to say, I had questions about Mr. Murdaugh's guilt, but I voted guilty because I felt pressured by other jurors.
But see, pressured by other jurors.
Right.
That doesn't matter.
That doesn't matter. It only matters if the communications with Clerk Hill changed her verdict in some way.
And also, we want to hear what 826 has to say, because this juror 630 says that this 826 and Becky Hill had private conversations.
Right.
Multiple times.
So to me, looking at this affidavit, I just don't know if they stick with the green standard, if that's enough. But it only takes one juror to say that if these improper communications happen, would it have changed the outcome in any way?
And I mean, I guess it would be possible even if she actually hears the juror say the things that Becky Hill said. Maybe when she hears them, she might say, well, this rises to above greed. You don't know, right?
Mm-hmm.
I mean, because she said she's left it open. I mean, it's still not great for Murdaugh's team. Don't get me wrong. I'm sure they think it's a big L coming their way. They have to think that at this point. So what was the proffer? I'm trying to remember what that part was. That was, Justice Toal.
Yeah, Justice Toal indicated that she would allow the defense to submit a written proffer. And the defense indicated that they would be submitting some more detailed affidavits, which someone responded to me on Twitter, which I thought was kind of a good point, is, okay, so they submit these more detailed affidavits. Toal's reaction may be, well, if it was so important, why didn't you include all this information on the first round?
Yeah, it's possible.
So then after this hearing, or not hearing, conference took place, the defense submitted a reply to the state's pre-hearing brief. And they kind of go through the same arguments of the legal arguments of why they think this case should apply versus this case. I don't know if that will sway her in one direction or another. One thing that I did find interesting in this brief was there was this communication from this person named Lucas Pierce, who was on a Facebook group. He lived in Indiana, and said that his ex-wife was on the jury and she already believed Murdaugh to be a guilty man.
Was this on the comments, actually? Like it was comments?
Yeah, it was comments, but it was submitted. But this was presented to Clerk Hill.
It was comments on a video is what I'm saying, though. A comment like on a live feed or something, right?
Right. It was a live.
Yeah, not on Facebook. It was
a live feed.
Yes, live feed. But you know how people can comment as the feed is going on. Yes.
And this person named Lucas Pierce has saying that his ex-wife was on the jury and that she had already believed that Murdaugh was guilty just because he was a man.
Yes.
It's not the egg jurors. This is a different juror. But this information was presented to Clerk Hill. But she did not bring that information to Judge Newman the way she did the information about the Facebook group involving the egg juror, who was believed to not to be favorable to Alec Murdaugh, that she didn't believe he was necessarily guilty.
And in this that we're reading, you're implying that Becky Hill made up the Facebook thing because she knew about this or whatever, like it was a complete made up thing.
Right. They're saying
Because we never did find a trace of it.
Right. And that maybe, I guess they kind of insinuate possibly that this Facebook post maybe gave her the idea
Yes.
about the Edgar Facebook
To make up a
page.
Facebook thing because there was this comment on this live feed. So it planted this idea. Oh, here's
Well,
what I could do. Saying
whether
X
that's-
said something.
Whether that's true or not, Justice Toal says she is not considering this Facebook stuff, but it is interesting that why Clerk Hill would bring one set of information to Judge Newman's attention, but not another set.
Because
And
they have
the
proof
one-
that she, in her email,
Right,
there's
and the
proof that she
one-
saw this.
And the one that she brought to Judge Newman's attention was someone who was believed Alec Murdaugh was possibly not guilty.
Mhm.
And this other person had already indicated that they thought that Alec Murdaugh
Guilty.
was guilty. So
Didn't present it. And they haven't, because of the emails that we have now, Becky Hill, we know that she saw this.
right.
Proof of that. More about it in Fitz News if you want to read more details.
Yeah, and we don't know if this will sway Justice Toal in any way or not.
There's a lot of stuff still shaking out there, and it doesn't mean that Justice Toal will listen to it or hear any of it, or whether it's legally important.
Right. Oh, and another thing I wanted to comment on, if this hearing does proceed the way Justice Toal envisioned it yesterday at the conference, it's probably only going to last a day.
Or maybe two, but
yeah,
yeah,
I
not
think,
the 3 days
Eric-
they blocked off.
Yes, Eric Bland said, how many days should my clients plan to take off? And will it be done one day, or there's 3 days allotted for it? Do they need to plan to be there all 3 days? And she basically said, no, it should be able to be done in a day.
Right. So maybe if she's only asking a couple questions, did you hear something? And did it sway you?
Exactly.
You could bang out through it. And it's only the 12, right? It's not any of the alternates or...
Unless something happens to change Justice Toal's mind.
But all in all, I think it's pretty unanimous vote from everybody we talked to who's an attorney that it was a big loser of a day for Alec and his team.
Yeah, I know. I think a lot of people went into this thing thinking, there's a good shot that he may get a new trial. And I think most people came out saying, slim shot that he gets a new trial.
It was a big turnaround,
based on the evidentiary hearing.
Yes. So there you go. You want to reach out to us? It's Impact of Influence on Facebook, Impact of Influence, the YouTube channel we're trying to get rolling. Evergreen Podcast is part of the family. We're always grateful that you hang out with us. We're looking into doing some other crimes and missing people and murders around the Southeast region. If you have ideas for that, send it to us as well. We're grateful, and we will talk soon.
All right.